Starting us off tonight to unpack all of this is NBC News legal analyst Danny Cevallos and gun safety advocate Fred Guttenberg, whose daughter Jamie was killed in the Marjory Stoneman Douglas school shooting. Danny, I'll start with you for some legal analysis. What did you make of Kyle Rittenhouse's testimony today?
Kyle Rittenhouse was very well prepared by the defense. Notice that he crowbarred in many times the magic words threat, because those are critical. And I'm so glad we have a gun safety expert with us, because I'm sure he will tell us that the word threat, that is what you're trained to do, at least law enforcement. You don't shoot to kill, you shoot to stop the threat. And if the threat is ongoing, you keep shooting until the threat is no longer a threat. And Kyle Rittenhouse, every time he had the opportunity to say the word threat, he said it. And you better believe that his attorneys will come back to that in their closing and argue to the jury that there is no question that Kyle Rittenhouse actually perceived a real threat to his safety of serious bodily injury or death.
So just as a follow-up, Danny, obviously he was prepped in terms of the content, the wording he was using, as you said, right? Using the word, those magic words. But what about the demeanor? Would a defense attorney tell a defendant to get emotional, allow themselves to cry, maybe get a little panicked in the moment? Would they encourage that? I'm not alleging that he faked it. What I am asking is, would a defense attorney encourage that type of performance?
What you're asking is a defense attorney above talking his client into doing a bit of theater? And I would say absolutely a defense attorney would do that. Guess who else would do it? Prosecutors. They would do it too. So sometimes some well-timed crying or emotion will help a case. Sometimes it's not very helpful. Generally speaking, I mean, it's a bit of a risk. So I don't tend to think it's the best thing to coach your client to cry at a particular time, because for exactly the reason that you might think it's not sincere. So it's a risky proposition. And the bottom line is, when a witness shows emotion, everybody interprets it in different ways. If you're on the side of the prosecution, it's crocodile tears. If you're on the side of the defense, it's genuine and heartfelt.
It's helpful. And I want to play one more exchange, Danny, from today. The judge was a central character. Judges are not always a character in trials like this, but this judge was. Let's take a look at that exchange. And I want to get your reaction specifically about the judge's behavior today.
There was another ex motion with regard to the defendant being at Pudgy's bar after a court appearance in January, in which he poses for selfies wearing a shirt that says "free as f***." I would like to ask the defendant if he posed for selfies after a court appearance with members of the public wearing that shirt. The jury's already watched him break down on the stand with emotion. I'd like to probe how heartfelt and sincere these emotions are when you go to a bar and you pose for selfies.
So this is the picture he's referring to. Danny, why would he refuse to let this be considered during the trial? I mean, he excluded it previously, but what was the reasoning for sort of that spirited exchange today?
Because it's impermissible character evidence. And I agree with the judge's ruling on this. The judge even himself said the only thing that really matters here is what he thought in the moment that he fired his gun. This is not only character evidence, it's not even a prior bad act. It's a prior subsequent act, something that happened months after the shooting itself. So I agree with the judge's ruling there. Defense attorneys or the defense is often the victim, so to speak, of these prior bad acts rulings. Because if the prosecution comes up with some alternative reason to get it in other than to show that the defendant is a bad guy, and that's really what it is. I mean, I would ask, what about that T-shirt is probative of what Kyle Rittenhouse thought, felt, perceived, and anticipated at the moments that he pulled the trigger? There may be other bad evidence against Kyle Rittenhouse, but I think the judge properly excluded this. And when the prosecution sought to introduce propensity evidence like this, the judge probably could have dialed it down a little bit, but I think he made the right call.
So, yeah, I think there's two levels to it. There's the merits of the decision and sort of the theatrics that were going on. Now, Fred, there are a lot of other aspects to this story beyond just the legal analysis of what we're watching in court. This was a 17-year-old kid who was able to get a friend to buy him an AR-15 with, pretty effortlessly. that weapon was the same weapon that was used in the Parkland massacre. Why do you think so many young men are taking up arms? They're turning to guns and acts of violence, whether it be to, say they're protecting the firehouse, or simply because they're mad about something. I mean, I think that there's something to that. What do you think?
Well, listen, and I just want to say, I'm not an attorney, and Danny, I was listening to your analysis all day, so thank you. Asked your question. Let's not ignore the past few years where you had a president telling them to do that. That's reality. I mean, you can't remove the rhetoric that was taking place with what happened here. I need to say something about what happened today, because your opening segment where you showed the judge, and he actually used the word bias. And so I want to talk about bias because I couldn't help but scream all day today when I felt like I was seeing bias. And, it wasn't long ago, I think last week, when this judge said, we can't use the word victim, okay, for those who were killed. So this entire trial to me has been somewhat hamstrung by that earlier decision. But this judge today let these defense attorneys run amok, presenting whatever theories they wanted. I mean, Kyle Rittenhouse showed up there with an AR-15 around his shoulder to provide first aid. That's what they were selling. But when the state prosecutors made an effort to cross-examine, the judge did not stop going after them, to the point where he even allowed the silliest argument I've ever heard over the pinch function of an iPad, okay? And bought into these defense attorneys' notion of artificial intelligence affecting what the jury is actually going to see. I want to go back to bias, because I was screaming at the television all day, and the judge's phone, we all heard it, rang with the Trump campaign song on it. Okay, I'm sorry, we have a problem here right now, and these were victims. Trust me, Kyle, when you show up and you at close range point an AR-15 at somebody and you shoot it, you know full well it's not just going to kill them, it's going to rip their body to shreds. That's what AR-15 bullets do. It's what they're designed to do. You clearly knew enough to know that. So don't BS the jury. That is a fact, but the judge doesn't want it heard.
So to that point about that AR-15 style rifle, he talked about why that was his gun of choice. Let's take a look at that.
You didn't pick out the AR-15 for any other reason?
I thought it looked cool, but no.
You didn't pick it out because you wanted to go hunting with it, did you?
No.
You didn't pick it out because you were going to use it to protect your house, correct?
Correct.
You picked it out because it looked cool.
I thought it looked cool. Guess that's the reason, yes.
Fred, you're calling for the Federal Trade Commission to investigate Smith & Wesson's marketing of the AR-15. Is this an example as to why you're doing that?
Listen, I'm so glad you asked me that, because yes, the gun manufacturers directly market their products to the mindset of a Kyle Rittenhouse, and they do it successfully. I can't, because of a federal law called PLACA, sue the gun manufacturer. But the lawsuit that I would have liked to have filed has been filed with the Federal Trade Commission, and I do hope they take action. I will say this, and maybe this is a conversation for another day. Listening to these arguments all day and what the judge was allowing, I couldn't help but think about how important that Supreme Court argument on the Second Amendment was last week. This is the exact kind of argument that was coming up there. And we need to put a stop to this. You know, Kyle Rittenhouse was an underage boy, not legally able to buy a weapon. He went to a place where he had no business being to protect a building he wasn't asked to protect. And he acts like he was there to just provide first aid with his AR-15. I'm sorry, you can't make this up.
No, you can't make it up. Unfortunately, it is all real and all happening. And Danny, just to sort of put a pin on the day's testimony and what happened in court today, putting Rittenhouse on the stand as the defendant is a risky move. We've seen other cases. For example, we were talking earlier about how George Zimmerman did not take the stand in his own defense. So speak to how this is a risk-reward balance that the defense has to walk, and whether or not you think that they prevailed in putting him on the stand without sabotaging their efforts.
Defense attorneys are very risk averse, and we also live in mortal fear that will be that one story in the courthouse of the dummy who put a client on the stand and just lost the case right then and there. I mean, I'm not kidding. I'm not being glib. It's true. And for that reason, defendants almost never testify. The rule is you only put your client on the stand if there's absolutely something that you need that you cannot get from anywhere else. And arguably, they didn't need to with Kyle Rittenhouse because there's so much video of what happened. They might have done it through cross-examination or analysis of the video. But in this case, it was a gamble that looks to have paid off because they put him on the stand. He hasn't really wavered from his story, and he's there. He's telling the jury what he actually believed, that he was in fear of his life, and he's sticking to the script and crowbarring in the word threat. He's been well coached. He's well prepared. Overall, this appears to be a gambit so far that has worked for the defense, but of course, the real test is the verdict itself.
Yeah, we'll have to wait and see how the jury is processing these images that we're seeing on the screen here. But I want to go back to the intro and remind folks that George Floyd was just, you know, they made him into the boogeyman, and he was the one that was killed. And in this case, you know, so many headlines today, leaving out the fact that Kyle Rittenhouse is the one that killed people. Danny Cevallos, Fred Guttenberg, thank you both for being here to start us off tonight. And Danny, I always love talking to you. You're like the only defense attorney I can talk to about a case I feel emotional about without getting upset. And I always appreciate you for that. Please stay safe, both of you. Hi, I'm Zerlina Maxwell. Thanks for checking out our channel on YouTube. You can see more from Zerlina by clicking any of the videos on this screen, and make sure you subscribe below to stay up to date on the day's biggest stories. Thanks for watching.